My name is Jed McKeehan, and today I want to talk to you about a few misconceptions of defendants or regular citizens that I encounter on a fairly regular basis in my criminal defense practice. And I want to talk to you about those today and hopefully give some more advice or information on these encounters. First thing I want to talk about is when you encounter police officers. Whether you're stopped in your vehicle or they come to your home and knock on your door and they ask for consent to search your vehicle or your home, you are not obligated to allow them to do that. Actually, I would encourage you to say no to those searches. There's nothing good that can be done by you agreeing to a search. Now, if there's exigent circumstances, is what they're called, if someone is in danger of dying or the officers are needing to protect themselves, they're allowed to pat you down for weapons or things of that nature, but there is no reason for you to allow them to search your home or vehicle. There's just nothing that you can be gained out of it by agreeing to do so. Make the officers go get a warrant and go through the proper channels to make that happen. Similarly, if you are being asked questions by an officer, I would highly encourage you to say that I want to talk to an attorney. I'm not answering any questions unless I have my attorney present. Another thing that you can do as well, and keep in mind this ticks off officers on the regular basis, but you're allowed to do this. Ask them if you are being detained. If they say no, then you are allowed to leave. You're not required to answer any questions or stay. You're not under arrest. You're not being detained, and so therefore you're allowed to leave whenever you wish. I would encourage you to ask, if you're feeling uncomfortable with the questions, am I being detained? If they say no, then you are allowed to leave. If you are actually arrested, some individuals believe that if you are not read your rights after you're arrested, this is some sort of get out of jail free card, or that you get a free pass, or the charges should be dismissed because they did not read your rights. That is not the case. Unless there is something that you've admitted to after they place the handcuffs on you, say, yes, I killed so-and-so, or yes, I was drunk and I was driving, or yes, I stole those items. Upon questioning, after you've been arrested, then you may have an argument. But if you have not admitted to anything after you've been placed under arrest, this argument doesn't mean anything. You haven't admitted to anything, so it doesn't matter that they didn't read you your rights. One other thing I want to mention is lots of crimes involve a victim, someone whose item was stolen or who was physically abused, things of that nature. Now, if the victim does not show up for court, sometimes that allows the charges to be dismissed, but that is not always the case. There can be other evidence, maybe that an officer saw something, or maybe the victim will the case will get reset so the victim can be subpoenaed and made to appear at court. Or if the victim doesn't show up, they may dismiss the charge, but they may reserve the right to bring that charge at a later time. So just, those are some of the things to keep in mind when you are charged with a crime that involves a victim. There are a lot of misconceptions that happen in the criminal when you've been charged with a crime and you are encountering the criminal system for the first time, and that's common. This is a first encounter for many individuals. I'm happy to talk to you about these issues, questions you may have, or anything else on criminal legal issues or any other legal issues. And you can find more about me at attorney-knoxville.com. I'm also on Facebook and Twitter.